The appointment of Justice Amy Coney Barrett to the U.S. Supreme Court is a victory for President Donald Trump.
This is a momentous day for America, for the United States Constitution, and for the fair and impartial rule of law.
She's Trump's third pick for the country's top court after he selected Neil Gorsuch in April 2017 and Brett Kavanaugh in October the following year. That stacked the court with twice as many conservatives as their liberal peers.
If this process has revealed anything, it's the supposed Republican principle was a farce. No principle at all and never was. Naked opportunism. A transparent, cynical, last-ditch grab for power. And of course, the continuation of their shameful lockstep subservience to President Trump, the most unprincipled president in American history.
Justice Barrett's career thus far shows she tends to favor big business. In 4 out of 5 class action lawsuits brought to her court by workers, she has favored with employers. She says her idol is the late Justice Antonin Scalia, whose rulings limited workers' ability to collectively sue companies, and the U.S. Chamber of Commerce and Industry lobbied aggressively for her appointment because of her pro-business stance. The newest member of the country's top court says she will keep her own political views out of the courtroom.
I will do my job without any fear or favor, and that I will do so independently of both the political branches and of my own preferences.
But how she interprets the law could have far-reaching consequences for the U.S. economy within just a few weeks when Justice Barrett and her peers announce a verdict on the Affordable Care Act. The case was filed by Republican governors who argued that taxes levied under this law, commonly known as Obamacare, are unconstitutional. If the U.S. Supreme Court agrees, thousands of jobs may be cut from the healthcare industry, and 20 million Americans could end up losing their health insurance. As she's just 48 years old, Justice Barrett is expected to remain part of the country's senior judiciary for decades to come. And whether or not President Trump is re-elected, Barrett's nomination, along with the other 2 judges he chose during his tenure, could be the most influential decisions of the Trump era. Mobin Nasir, TRT World.
Well, for more on this, Jonathan Entin joins us now from Oberlin in Ohio. He's a professor of law at Case Western University. Welcome to the program, Professor. Now, you once clerked for the then Judge Ruth Bader Ginsburg when she was on the US Court of Appeals for the DC Circuit. So I'd like to start by getting your general views on her successor, Amy Coney Barrett. Do you believe that she's the radical conservative zealot that critics would have us believe, or do you think she'll be a more balanced addition to the Supreme Court?
I don't really know very much about Justice Barrett's views. I know that she is generally a lot more conservative than Justice Ginsburg was, but I also know her mentor, who is the president of the Catholic University of America in Washington, D.C., I've known him since he was a law professor. He thinks extremely highly of Justice Barrett as a person, and I know him very well. I trust his judgment, but I do think that her views will be, on many issues, noticeably more conservative than Justice Ginsburg's were.
Okay, now we know much has been made about her positions on some key social issues such as LGBT rights, women's reproductive rights, but being a business program, can I ask you about how she might impact some key economic issues? Now, the Center for American Progress says her rulings have sided with corporations over people 76% of the time. Are you worried that she might favour big business in favour of workers' rights now that she's on the court?
Well, I think generally Republican justices tend to be more sympathetic to business as opposed to workers. But you have to take the cases as they come. It's not as though any justice starts out by saying, I'm in favor of business or I'm in favor of workers, and then just consistently votes that way. the language of the relevant statutes or regulations, the facts of the case will make some difference. But most of the cases that get to the Supreme Court are legitimately hard in the sense that there are defensible legal answers. And I think it is likely that Justice Barrett will be more likely to side with business than with workers if you look at the run of cases over the years that she's on the court.
Okay, now in her writings, Barrett has been critical of the reasoning that led to the Chief Justice of the Supreme Court, John Roberts, to cast a pivotal vote in preserving the Affordable Care Act. Now, as we heard in Mobin's story, Obamacare, as it's also known as, will also face another challenge in the Supreme Court just 1 week after Tuesday's presidential election. Do you believe that now that Justice Barrett is on the Supreme Court, that Obamacare is under threat and could actually be taken away?
It is under threat in the sense that the lower courts have already said that the law is now unconstitutional. I do not believe that the reasons advanced by the lower courts or by the states challenging the law make much sense. And indeed, some of my most conservative colleagues and friends think that those arguments are very weak. But it is possible that the court will find them persuasive. The question then becomes, what does the court do if it does conclude that there is now a constitutional problem? The question is, will the court take down the entire statute, or will it take down only the individual mandate, which is the only thing that's actually being challenged at this point? The argument is that because the individual mandate penalty has been set to 0, that somehow the entire law comes down. I think that that is a very weak argument. Indeed, Justice Barrett's mentor, Justice Scalia, used to say that Congress does not bury elephants in mouse holes. And the idea that the entire Affordable Care Act is now unconstitutional because one piece might be, that looks like the ultimate elephant in a mouse hole, especially when Congress repeatedly tried and failed to repeal the statute altogether. It is just hard to believe that the court would accept that the entire law is now invalid.
Okay, Professor Jonathan Entin, we'll have to leave it there, but thank you again for joining us on the program.